On to this now, the Roodepoort Magistrates Court in the west of Johannesburg is expected to make a verdict on the second bail application made by murder-accused Nkululeko Shoba. Shoba is accused of murdering his then 28-year-old girlfriend Tsegofatso Pule. Shoba was arrested in February after his alleged accomplice, Muzikayise Malephane, confessed to killing Pule. We will now cross live to the court proceedings. Let's take you there.
The court will accept the evidence. It is upon this acceptance that the court decides whether the case is strong or weak. Close the quotation. The state has presented evidence that it was the applicant who contacted Mr. Malephane before, during and after the deceased's removal from his house. And on the date of the murder or even before, not only by way of social media but also a meeting a day or so after the murder of Mrs. Pule. It was also stated that Mr. Malephane is known by the accused as a cigarette seller. This must be tested at the trial. The state witnesses denies this and shows in any case that during lockdown, relevant to the breaking of the rules by the applicant, where these rules were instituted by the government in the interest of the community. The state also presented evidence that the accused, and the state was honest about this, initially exonerated himself, but always implicated the accused and no other person, as he did in the Section 105 plea agreement, that the applicant was the one that was involved in the death of the deceased. The applicant then gives further and elaborates and embroiders on the facts he previously placed before the court in the first bail application and asks the court to now reconsider these aspects on both the old and the new facts and make a finding that indeed he has now shown on a balance of probabilities that it would be in the interest of justice that he be released on bail. These are not new facts as anticipated in the bringing of a new bail application. I will, however, refer to some of these. The court dealt with the presumption of innocence, which is strike law in the constitutional dispensation of the Republic. The applicant already at the first bail application, at paragraph 1.18.3, indicated that he had cooperated with the police during the investigation. The mere fact that he now elaborates how he assisted with the CCTV at the complex is not a new fact, as it was known at the date of the first bail application. In any case, the police deny that he assisted with the CCTV from Apcan on the corner. This is in any case a fact that of the nature that could easily have been discovered without the assistance of the applicant. The CCTV does not show the number plate. The state now does not dispute that the applicant assisted with drawing the attention to the CCTV at the complex, but does dispute that the applicant had made them aware of the CCTV of Apcan. This really is therefore not a new fact that was specifically mentioned in the first bail application. It was indicated in the first application that the applicant will not tamper with the evidence. He again just elaborates on this fact The state, however, disputes this and shows that the applicant had consulted with a state witness without the consent of the state. And it must be reiterated that it is not the state that carries the burden as implied in paragraph 18 of the new bail application. To then say that the state infuriated the public and that the public is now knowing that Mr. Malephane is the murderer because of a rave is the mere say-so of the applicant. However, it is the applicant himself, as stated in the first bail application, that death threats were made before he was arrested. And when he was not even a suspect. Again, this is not a new fact, but existed at the first bail application. What is now placed before the court is the evidence by the state, rather, that the prima facie case against the applicant is indeed prima facie as they stated during the first bail application. The fact that the threats no longer exist is on the mere say-so of the applicant. If they had any evidence of this, the court is sure that this would have been presented by way of statement, which is not done. This would have, of course, been a new fact to consider, because this was one of the reasons why the bail was refused during the first bail application. The applicant is now unemployed, and this is indeed a new fact. The applicant knew that he could reopen his case, and that is why this evidence was placed before the court at a later stage after the state had presented their evidence. This now rather also shows that the applicant is unemployed and that he has no income, and that many of the aspects whom he would be supporting now falls away. The applicant avers that in the light of his dismissal, he needs to appeal the dismissal, but he also states that he has already lodged the appeal, although he is in custody. He does not say how he managed to do this, whether it was through his attorneys, etc. Therefore, the court finds that he does have means to lodge the appeal, and therefore the suggestion is that even if it's necessary for him to be taken to the hearing on appeal, he would be able to do so. At the first application, certain words were uttered by the applicant. It is stated by the state. The applicant did not deny this, although he knew at that stage of the fact that he would deny this. Exactly what was said in S versus de Villiers Supra is now applicable. He cannot now address the problems encountered in the first bail application or fill in the gaps in previously presented evidence. The same can be said about the applicant's averments in paragraph 22, that he is not a flight risk and why he did not flee in the past, and this was already dealt with during the first bail application, and nothing new has been brought to the fore. Applicant also now, in his application, although he is now unemployed, shows that he needs to be with his grandmother, as he is the one that has always been attending to her needs, He states this, and there's also a statement from his grandmother. However, he does not disclose that his father and mother both receives pension and that the brother is available to assist as they stay in the area. So the grandmother is not destitute without the assistance of the applicant. To, in paragraph 26, again attack the state as being untruthful or concealing evidence that the applicant assisted the police in the investigation, that the applicant, this was disclosed at the first bail application. The state did not dispute this, so this is also not new. And see Matabula above. The applicant wants to have his house and his pension to be taken as surety for the amount of bail that he can pay. However, he does not disclose that the house is both in his and his Lobola partner's name. He, however, submits a statement to prove that the lady is not his wife, but does not disclose that the bonded house is in both their names. The applicant has placed nothing compelling before this court when taking into account the new evidence not known previously and the elaboration already on the known facts that exceptional circumstances do exist, why it would be in the interest of justice that he be submitted to bail. Bail is refused. The court will, that's our role.
Yes, the judge was for the indictment is ready. Just wait for it. The matter will be adjourned to 3 weeks for such purpose. I suggest the 17th of May for the indictment.
Suitable, sir?
Sir. Suitable, Your Worship. Thank you. Then that will be our
the applicant to come to court in custody or the accused or IVR?
Rather, he comes to court so that the indictment can be served.
Thank you. Postpone to the 17th of May, sir, so that the indictment can be served on you and you be submitted to the High Court for summary trial in custody.
Thank you, Worship.
The court will adjourn.
Well, there you have it. Nkululeko Shoba will not be going home. Bail has been refused and he will be going back to court on the 17th of May where an indictment will be served. Hasina Gori will be bringing us more detail on the story in a bit.